Welcome to Lawyers Who Care, the video show podcast that highlights attorneys who go above and beyond for their clients. And on each episode, we will meet a new lawyer and they will share stories of when they went beyond legal counsel for the benefit of their client. My name is Andrew Samalin. I'm the principal of Samalin Wealth, a nationally recognized wealth management firm for lawyers, their firms, and their clients. And let's applaud Lawyers Who Care and learn from them. Today, my guest is Yandy Reyes from RES Law Firm. Yandy practices estate planning and estate litigation law in New York City and Nassau and Westchester counties. Welcome, Yandy.
How you doing? Thank you for having me.
My pleasure. So, Yandy, tell us how you came to the law.
So it's an interesting question because I'm a cliche, right? The cliche is the child who is told, oh, he's gonna be a lawyer. He wants to be a lawyer since he was young. But the thing that happens is I don't know if it was because someone told me or because I just instinctively said, oh, you know what? That law profession sounds cool. Sounds awesome. Sounds like an interesting thing to do and learn about. But the reality is I was always very argumentative. I always try to bring up propositions and points and see different perspectives. I was always curious, inquisitive. So people just instinctively saw me as, oh, this guy, that's the lawyer. That's the lawyer of the family. That's the lawyer family. And when you're so little, right, when you hear it so much from throughout the entire family, you just start saying, hey, maybe this is the thing. This is the road. This is what I need to start looking into. But I didn't know what it was. I didn't have any lawyers in my family. I didn't know anyone who practiced law or anything. I did know, right? People always said, oh, lawyers make a lot of money. Lawyers make a lot of money. And then I said, okay, well, that's a checkbox, right? That's a good thing to be aiming towards that instead of the alternative. And then, as I grew up, I started to notice that there are rules and law permeates everything. And whenever you learn that rules and laws permeate everything, you start to learn it's like, okay, well, it's important to know what the rules are. So then I started to notice, I was like, okay, I definitely want to be a lawyer because I want to be able to protect myself and protect my loved ones. And I said to myself, the only way that you can really protect someone is if you know what the rules on the board are, right? The game of life, if you will. And then it just led me down the path of saying, hey, this is what I want to do. I want to learn law. I want to be effective at it. I want to be able to make sure that my loved ones and myself are never the victims of ignorance, never the victims of not knowing something or not knowing something ahead of time or planning effectively to take certain options and actions. So then that's where I ended up. I said, oh, law is for me. And it's good. It's good to have been early on a kind of a groomed and understanding. That's what I wanted. And then the rest of my life, everything seemed to have confirmed it. And I said, oh, this is it.
Excellent. And how did you come to your focus of estate planning and estate planning litigation?
Oh man, when I started law school, I was all about family law. I was in another situation where I was like, family law is where it is. These people are fighting. They're talking about divorce, alimony, child support, child custody. This is such an interesting area of law. I can help these people through compassionate care and such. Resolve their issues in a record time, if you will. I was so optimistic, yet I also noticed how naive I was. When I started to learn the law of family law, I came into law school, family law, family law, family law. I took a family law course and I was like so disincentivized by the structure of the, contractual agreements, if you will, that the government imposes on a marital couples and child custody and child support and all this stuff that I just said, no, I can't do this. I can't see myself doing this. So then I found myself in a somewhat a panic. And then I noticed, no, what's the panic? Let me just see what else is available. So then I took an elder law class. I took an elder law externship, and then I took a seminar. And when I took the elder law, I just noticed, I was like, wow, this is a way to preserve an individual's dignity and autonomy. And more importantly, when people reach out to us, it is because there are some obstacles in the estate litigation, probate, and administration side where there's just something stopping them from being able to unlock all these, the legacy left behind. And I said, what a nice area of law where I can help families basically get money from their legacies, right? From their parents. And it's kind of like, at that time, I was like, wow, that's kind of like a connection between that other world and this world where you have this person reaching down and providing this legacy to the individuals who were left behind. And then there's two, right? The estate planning is the planning side of it, so that then you avoid messes and issues, where the estate probate and administration side is the reaction of either planning or lack of planning. And I just noticed, I was like, wow, what an interesting area of law where you just have a win-win all around. Now there's contests and there's complexities, and I'm going to share one. But the point is, it's still a situation where you have a win-win proposition when things are done right. And there's so many rules and regulations that basically when the person in it, and I just started to notice, I was like, this is an area of law.
And you had in when we were setting up this call, you had mentioned you had a story that you want to share. Do you want to tell us a little something that happened in the past? And of course,
So
changing the names of the innocent.
yeah, no problem. So I think that your call for fame, the call for fame in this law in the podcast is how do you go up and beyond for a client, right? And the fascinating thing about this is that lawyers go up and beyond in so many different ways, right? And the way that I want to phrase this is by trying to understand what does it mean to go up and beyond for a client, at least in the way that I'm going to explain. I think that we would both agree that we go up and beyond for our clients when we're able to deliver effective, efficient, legal conclusions and outcomes that have clear expectations when you set a strategy and tactics in place, and then it leads the client to from where they are in a challenging situation into a resolution that is predictable and creates a very favorable result in an expedient fashion, right? If you know what I mean? Would we agree that if you can cost effectively get to the outcome in an efficient manner, then that would be a going up and beyond for the client, right? I think that would be a fair way to say it. So my client calls me on one day. We get a free consultation. We offer free consultations to explore options, right? And then the client tells me that the decedent passed away. He has no children and he has no spouse. So when a person passes away with no children and no spouse, the next question is, does that person have living parents? So it turns out the father had passed away. The question then turns, does the person have any siblings? In this particular case, the decedent had a half sibling who had never known about this person, who basically, long story short, father had this child and then left. And basically, it may have been that the father didn't even know the child. So there was an issue of abandonment. There was an issue of basically non-care negligence of the child. But my client was the family, the maternal side of the family that had taken care of the child until the child was 50 years old. They basically the entire time. And this person had some special needs at some points, guardianship, some levels of complexity. Point is, bottom line was the person who stood to inherit the $400,000 in this particular case was either the stepsister 100% or the siblings on the maternal side if the father was to be disinherited. Does that make sense?
Yes.
It's a little complex, but the point is it's a zero-sum game where one side is going to lose and the other side is going to win 100%. So client comes to me and says, oh man, I really don't want to go into this litigation. I really don't want this to get so long that basically we litigate this for 5 years, 6 years. And then the lawyer fees by itself will take up $100,000 or whatever it is, right? And then I said to her, I was like, look, and this is where the initial phases of going up and beyond for the client starts. Setting a reasonable expectation, having that trust, care for the client to help them understand, hey, I get what you're going through. I'm going to try something in your case that may work, right? If we're able to reach out to the other side, be transparent, be accountable, be real, be honest, right? So lawyers, we can't lie. Like that's the reality is we can't call someone and say, hey, I want you to sign these documents because if you sign it, then you don't have to worry about this or whatever it is and misrepresent the facts. We have to be truthful about the facts. We cannot, we have to create a meeting of the minds that allows the person to understand the situation. Turns out we set a plan in place where we were going to be reaching out to the other side, communicating to them, hey, this is what's happening. And the reality is, the way that I went up and beyond for this client was immediately from the beginning, I was prepared to effectively litigate against the persons, the other sides, but simultaneously try to reach a reasonable resolution that allowed for no litigation to occur at all. Turns out, I get on the other side, we get on a call. Of course, whenever you hear an attorney calling you and telling you, hey, this is what's happening and this is what you may be entitled to, this is our position, this is what could happen on your side, there was a level of trepidation and apprehension from the other side, right? Because that was the half sibling. Turns out that the person was legally inclinated and understood that I came from a good place, right? I came from a reasonable perspective. And because I had been so transparent to them and because of how I was communicating what I was communicating, even though it was very complex, and I create a little a little thing here that basically highlights it, right? This is the decedent, child, no children, no spouse. The next person who is the heir is the parents, who then is the half sibling. But if it's not the half sibling, then it goes to the sibling. The law at play was EPTL 4-1.4, which basically says if a parent it basically abandons a child or neglects a child before the child becomes an adult, then that parent is disinherited, right? So what was our position? Our position was, if we had to litigate this, we were going to prove that that family actually didn't know anything about him. And that family, because that family didn't know anything about him, it was clear that there was an abandonment in the matter. So within the first 5 to 10 minutes of that initial conversation, I had already gathered what I needed to be able to create the legal leverage if we needed to fight. I did it in a very innocuous way in order to not raise the defensive, because if you raise the defense too much, the person is going to want to attack and it's going to want to go to the court system, because ultimately it's better to go to the court system and have an attorney present and litigate on your behalf than to be misdirected or anything like that. But because I had already gathered what I needed, I was very safe if we had to go to litigation. Turns out this family on the other side, it stood to gain if they didn't litigate too, because they had an assured settlement and resolution and they knew what they were going to get. Or they could lose everything by me fighting against them and proving that the abandonment. Turns out we were able to, in effect, resolve the issues very favorably for the clients in a way that allowed our client to get a better deal than what she initially was willing to get. And it allowed the parties to come together so well to the point that the rest of the case didn't need litigation, and effectively resolved it at a very cost-effective way.
Wonderful. By the way, just so people know, this is my guest today is Yandy Reyes of Res Law Firm. Yandy, can you provide our audience with your contact information?
Yeah, so we are in practicing attorneys in New York. The best phone number to reach us is 646-577-9022. Again, that phone number is 646-577-9022. In essence, you call that number, you request for a free consultation. We then secure your seats and we can go ahead and give you a free consultation so you can understand your options, right? We also are at estateplanningReyes.com. Again, that's estateplanningReyes.com. And just like Lawyers Who Care, we are going to be launching a podcast within the next month. It's called Empowered by Law. Similar to this, not really. It's going to have its own niche, but Lawyers Who Care is doing a fantastic job. We really appreciate Andrew and what he's doing, getting us in the forefront so that then you, the audience, can understand what kind of benefits lawyers and professionals specifically provide in your matter, whether you see it or not a lot of times. And sometimes it's that special touch of a lawyer doing something specific in your case that pivots the case dramatically and changes a challenging situation into an advantageous one.
Wonderful. By the way, speaking of which, and thank you for the plug, this has been the Lawyers Who Care video show podcast that does highlight attorneys who go above and beyond. Yandy is a perfect example. If you're an attorney or no one that does, feel free to reach out to us, 914-666-6600. Number again, 914-666-6600. Yandy, thank you so much again for joining us today.
I appreciate you. Thank you so much.